Good morning. This next issue is S-166, which is an act relating to utility construction work sites and consumer protection. And we have scheduled for this morning to mark up the bill. And I thus far have not seen any changes to the bill. And Maria Royale is here from Legislative Council. Since there have been no suggested for changes, I know we have a couple of other people here. FX Flynn, who we heard from last week, and I don't remember if we heard from Kyle Landis. We did hear from Kyle Landis Moreno last week. So, and Jackie Folsom. Are there any suggested changes to the bill? No? Okay.
Well,
Mr. Chair.
Yes.
Sorry, I didn't know if you're asking the potential witnesses or just the committee members.
I'm asking potential witnesses if there are things that you would like to see changed in the bill. I mean,
Yes.
if you're opposed to the bill, that's fine, and we'll take that into consideration. But are there changes to improve it?
Yes, this is Kyle Landis Marinello, General Counsel at the Vermont Public Utility Commission. We would have some suggested changes, as I mentioned in earlier testimony, in terms of where the rulemaking occurs. And we did suggest, we thought if we were going to do a rulemaking, probably 3.700 would make more sense in terms of what gets amended to include this type of change. And I also mentioned if there's a policy decision to require these workplace site standards, and it's really just putting that requirement in as a legal requirement on all contracts for this type of work, it strikes me that that would be something that could just go in Title 30 as a requirement for any attachments to utility infrastructure. And then our current rule would actually capture that. And so it would immediately go into effect without us having to go through the long process of a rulemaking. And the other thing I flagged is just the way this is currently worded. It just talks about the utilities having liability. And I think I mentioned in my previous testimony that I wasn't sure if that was the intent, because the entities that caused this particular incident were attaching entities. And so that's different from a utility. It might be a utility that's attaching to utility infrastructure, but it could be other entities that that aren't actually defined as utilities. And so those are all things that I would think the committee would want to look at.
Right. Maria, I've obviously messed this up because I didn't realize there were changes, and you did ask, and so my bad.
well, let's do them.
So, do you have language, Kyle?
I don't have language handy right now. I apologize, but I can easily get that to Maria later today.
All right.
Or I could take my best stab at it now if you wanted to. I think that the main thing is, instead of it being phrased as "we shall amend this particular rule," I think it should be a change to Title 30 to just put in a requirement about worksite cleanup and the provision about liability.
Okay. Jackie Folsom. You wanted to comment?
Yeah, thank you, Senator Sears. We would support Mr. Landis Marinello's comments. I think these were suggested the last time, and having to not have to go through rulemaking, but putting it in statute seems a much more efficient way to do it. And we would agree. I've heard the testimony on changing it to Rule 3.700, and that seems to make more sense also. So
Okay.
any of those changes we would support. Thank you.
Okay. Mr. Flynn?
Yeah, I just wanted to circle back and say that, I believe that, probably contracts for anybody doing this sort of work already make provisions for cleanup and so forth. And it's great to have the state have some oversight and the ability to assure that that's the case. But as I've said, even if this, were in place, it wouldn't have made any difference. It would not have prevented what happened from happening. And I'm just concerned that, over time this will get lost sight of. And I think the real issue here is how do we more rapidly get help to what are some practical things we can do to prevent this from happening? I think number one, we can put signs on poles. I've initiated a conversation with the heads of the utilities in the state toward that end. Number two, it seems to me that we can set up some kind of mechanism that the state agricultural department could have under its authority that would basically turn it into an insurance subrogation deal. And then those are like practical, real solutions, whereas, S-166 is kind of like a feel-good measure that makes people feel like the legislature's doing something. But I don't really think it's going to make a difference to what actually happens out in the field. I'm sorry, that's just my, personal take on the whole deal.
Do you think people won't clean up?
No, I think for the most part, the people who do this work do clean up. I don't think that there's, I think we know of three things that have happened in the state over the course of the last 20 years that we can point to as times when people didn't do their job. I wish we could legislate that everybody had to do their job well all the time. It would make the world a better place. But, Bill Belichick has a big reputation for getting to the Super Bowl just by insisting that people do their job.
I know that. As a
there's a
Patriot
reason
fan,
for it.
I'm a Patriot fan since 1960, so I realize that it doesn't always, not everybody always does their job, but I do think this is more than just feel good, in my opinion. But that's just my opinion. Jackie?
Senator Sears, I feel your pain, but I've been a Cleveland Browns fan since 1962. So, there's no hope for me whatsoever.
That may be even worse.
I appreciate Mr. Flynn's suggestions, but this is a private property issue. It's not just an ag land issue. It's just that the ag land has been the ones that have found the challenges where these wires have been left. We don't know that this stuff hasn't been left back in the woods or anywhere else. And, as far as a feel good, I think that this will give people the ability to say, hey, there's money coming into the state. This is a wonderful thing. We've got to get this stuff done. We've got to get lines out and broadband out, but we also have to be mindful of private property rights. And that's what we feel is an issue here. We don't know where else it might be. They might have piles of wire. We don't know if people are cleaning up. And I've been working with a lot of with my own CUD to make sure that there's an education process going on. And I think that this bill will help make that happen. So I hope you'll support it in the changes that have been proposed. Thank you.
Thank you. All right. I think I hate to end the meeting early, but are there any other comments or questions? Did we all know where we're going?
Maria.
Maria?
Good morning, everyone. I just wanted to clarify a couple of things because you've heard some proposals, and I just want to make sure the committee is in agreement on what you might want to see in a new draft. So let's just say that the first decision point for you is, would you like this to be rulemaking, or do you feel like you have enough information to set the requirements into statute at this time? And would you like to see language in Title 30 that attempted to do that?
Yes,
Yes.
I do. That's Kyle's position, right?
Yep.
Yeah.
Okay.
Yeah.
So I can work with Kyle on that. And then the next question, you heard testimony from two farms. One had to do with fiber optic spools that got into the hayfields. The other one had to do with chemically treated utility poles. So that was not kind of the telecom attaching entity realm. So different subject area. As I pointed out last week, there are some existing PUC orders that set best practices for utility poles that are treated with preservatives. Now, I don't know that they would have addressed with the specific testimony about the goat herd that you heard about, but that's kind of a separate issue. So the only reason why I raised that is because you heard a proposal that one of the big concerns is fiber telecommunications, which is covered by Rule 3.7. And then there's more general construction worksite cleanup, that might cover other things. So are you leaning more towards focusing on the fiber, Rule 3.7, specifically dealing with that, recognizing that other construction worksite might be covered already, or there might be other? Do you have a sense of that, or?
I wanted to keep it simple, but committee. I mean, I don't want to get into the chemicals used on the poles. I think that's beyond the scope of this committee. That'd be a
Okay.
natural resources issue if they wanted to get into.
Okay. And then the other thing that was
Bruce
brought
may
up.
disagree.
Oh.
Senator Bruce, do you want to get into the poll?
No, I agree.
Oh,
I wanted to ask the committee how people feel about, we had testimony that the current setup doesn't allow people like the Hoyts to recover. If there are fines assigned, they drop to the general fund. And maybe that's too complicated for this bill, but it seems like in part it came out of this situation with the witnesses that we heard. And so if there was a relatively simple way to make sure that people could be made whole in these incidents where there was, in this case, an uninsured subcontractor, I would be all for adding that. If it's going to take a whole session to parse that out, then maybe that has to wait.
Can I say something?
isn't there a cause of action already, Maria?
There is a cause of action in civil court, and I believe there's litigation now going on. The proposal, the bill, also provides or proposes to provide for a cause of action under the Consumer Protection Act, which would allow for greater enforcement in that the Attorney General or the state's attorney in the jurisdiction where the harm has occurred can bring the action on behalf of the harmed consumer. It also allows a prevailing consumer to recover attorney's fees and punitive damages. So there's some enhanced enforcement by making violations of the statute or rule enforceable under the Consumer Protection Act. So that was going to be one of my next questions is, do you still want to keep that remedy that's in the current version of 166 in your proposed draft?
Yes.
Yeah, I would be in favor of keeping that.
Mr. Flynn?
Thank you. Two things. Number one, the subcontractor was insured. The insurer is still involved. The insurer has reconsidered their decision to deny coverage. And so I just wanted to be clear about that it was not a situation where the subcontractor was uninsured. The second thing is that the filings that I've seen in this case where there was consumer fraud was alleged, the argument that's being made by parties to the case, not EC Fiber, is that there's no consumer relationship between the Hoyts and Eustace, and so that part of the lawsuit should be thrown out. So this is why I encourage you all to log into the Orange County Court and read these filings, because that may give you some insight as to how we might want to change Vermont statute.
Okay. Thank you. Any further?
So may I ask a question?
Yep.
So does that mean that even under this, the way the language that Maria was talking about was that the relationship between the Hoyts and the Eustace, I think it was, they would not be considered a consumer, and even under this language, that wouldn't help them because the relationship there is not as a consumer? Is that the way I understand you, Mr. Flynn?
Well, so I'm not an attorney, but that's what I get from reading the responses to the lawsuit, is that they're saying, well, under law, there's no relationship. It does that law does not apply.
And this language does not clear that up, that the landowner is actually the consumer.
Right. If I were in your shoes, if I were one of the senators on the committee, I would be wondering, like, okay, we passed this, we make this part of it, and then there's a situation like this. Somebody goes to court and says, well, the parties are not in a consumer relationship, so it doesn't apply. And the judge goes, yeah, that's right.
Mm-hmm.
The legislature didn't really, they may have intended it to, but they didn't accomplish it.
Thank you. I guess I need more information on how that would be accomplished.
Well, I don't understand how the wording that I see here in section 2 is, section 1B says, a violation of the Commission's worksite cleanup rules adopted pursuant to this section, obviously that's going to change, or any contract provision applicable to responsibility and liability for worksite cleanup that results in harm or injury to any person or property constitutes an unfair act of practice in commerce under 9 VSA 2453. So I would think that anyone would be a person who suffered harm or injury. The question was, did they suffer harm or injury? And the answer, I think, to the animals is yes. So they had harm. There was injury to the animals. There was harm to the property owners. So I don't understand how they wouldn't be covered under this.
I agree with you on that, but my question was around also the ability to file under the Consumer Protection Act so that the AG's office was involved. And if that would, if they are a person who is harmed, but would they also, extending it to the Consumer Protection Act to get the AG's office involved, would they be considered a consumer under this? They are a person who can sue because they were harmed, but that was just, anyway, that was my question.
Well, I mean, shouldn't we put it in anyway? I mean, every case is different. And, you know, and every judge before it goes is different. So it seems to me to have it in the consumer protection piece in there could be valuable in a case. Maybe not, but maybe yes.
I'm okay with that. I just wanted to make sure that we were making it absolutely clear.
Maria, I thought it was clear, but
I think it is clear because any violation, if there's harm, and you're defining a violation of the rule that causes harm or a violation of the statute that results in harm or injury, any action going forward would be enforceable by the Attorney General's office. So I'm making a distinction between any existing litigation or any attempt to apply the law retroactively, which could result in other problems. Well, you do have some authority to apply laws retroactively. That can be problematic if there's pending litigation,
right.
if there are vested interests at stake. So I'm not sure that you could do that to make it retroactive to cover existing litigation. But so this would be prospective. And I do believe that any injury or harm as a result of a violation of the statute would be enforceable by the Attorney General on behalf of a consumer.
Thank you. Anything else on this bill? I mean, I think we're pretty close to having agreement and just a matter of seeing a final draft. Can we shoot for Friday morning, Maria? Would that work for you? Okay. Why don't we Peggy, schedule about 15 minutes Friday morning?
After 265 or before?
After. I don't think the judicial nominations are going to take, if Maria sends this out and we've got pretty much agreement everywhere, I think we can do this in 10 minutes. So I was thinking that we would do it at 11 and then have the judicial nomination. They haven't taken more than 15 minutes, any of them. So.
Yep. So Maria at 11 and 11:15.
Kyle, is that a problem?
No, Chair, that's fine. The one issue when I work with Maria on the language that I wasn't sure if it had been resolved was whether the liability was just on utilities or if the intent was to have it apply to attaching entities as well.
I think attaching entities.
I think so too. I did make a note of that. I think the point is well taken. The term utility is a little bit nebulous under current law. So I can work with Kyle on coming up with an appropriate term, whether it's the project contractor, ultimately, to the extent you want to have assigning liability. But yes, I think that's something that I can work on and have some language for you.
Great. All right. Are there anything else on this one? Okay, Peggy.